America is the freest country in the world. Just ask anyone who's never been outside of the country. But it wasn't always this way. What if I told you that the US used to make all kinds of wacky things illegal? The great con man Harold Hill once convinced a town to allow a boys' brass band so kids didn't fall victim to dangerous crimes like gambling, smoking, or reading Balzac.
Balzac.
But what else did America once ban? Now, Americans have always been suspicious of dancing, and we have the Puritans to thank for it. Way back in 1684, an OG Boston Scold named Increase Mather published an anti-dancing pamphlet called An Arrow Against Profane and Promiscuous Dancing, which argues that dancing, quote, drowns out the quiver of the scriptures. Thankfully, Americans excel at finding ways to get around oppressive laws. In the 1830s, people organized play parties, no, not that kind of play party, where they played children's games, allowing them to chant and clap as a way to avoid bans on dancing. And these parties persisted until the 1950s. Laws banning dancing almost always started at the city level. See Elmore City, Oklahoma, which made dancing strictly illegal in 1898. That law stood for almost 90 years until a group of high school students wanted to overturn the ban and have a real senior prom with dancing. The students faced opposition from the city's religious leaders like this guy.
The beat of music, the curves of the body, the display of the outward person, we don't believe is congruent with the principles of Bible doctrine especially.
But the students held bake sales and fundraisers for their prom. They taught each other to dance, and eventually the city council repealed the law by a margin of 3 votes to 2.
Lisa Rawlings was a sophomore at Elmore City High at the time. Her dad, the mayor, helped change the rule. She says a new boy in town, pictured here, got the ball rolling.
So I think Leonard's probably the one who asked the question just because he was an outer towner.
Now, Leonard's real name was not Kevin Bacon, but when People magazine covered Elmore City's prom, it got the attention of screenwriter Dean Pitchford, who went on to write the screenplay for Footloose. Today, Elmore City hosts an annual Footloose festival where, as you can imagine, everyone cuts footloose. Now, even after Footloose, small-town dancing bands still stuck around in many parts of the country. The Supreme Court held that social dancing is generally not covered by the First Amendment, whereas partially nude dancing is expressive enough to be worthy of First Amendment protection. That gave towns cover to regulate social dances, and so dancing was effectively banned in places like Pound, Virginia, until well into the 21st century. Now, Pound's anti-dancing ordinance banned dancing in any place open to the public that did not first obtain a dance hall permit from the city council. The council was not allowed to issue a permit, quote, to a person who is not a person of good moral character. And the council was also required to consider the proximity of a proposed dance hall to residential areas, churches, or schools. And you can probably guess what the cutaway is going to be right here. Well, obviously someone did think of the children because the prohibition on dancing had a chilling effect on its citizens' desires to do the twist. No one even tried to apply for a permit until William Elam, the owner of the Golden Pine restaurant, applied for a permit to host country line dancing. But Elam withdrew the petition after 200 pitchfork-wielding townspeople showed up at a city council meeting to oppose the application. But Elam sued the city and won. The town argued that it had a legitimate state interest in stopping people from drinking too much. The court agreed that this was a legitimate concern, but the ordinance was so broad that it applied even to places where alcohol wasn't consumed. For example, a for-profit performance of the Nutcracker Ballet would require prior approval from the town council, even if it were performed in a place that did not commonly serve or sell alcohol. The court ruled that the terms dancing, moral character, and proper person were unconstitutionally vague and overbroad because the Pound Town Council, yeah, it's the Pound Town Council, had the sole discretion to bar public performances of dances, social or otherwise, quote, merely by declaring that the sponsor of such a dance was an improper person or one who lacked good moral character. And despite this ruling, the city was undaunted by this setback and enacted a new dancing ban. Elam continued hosting dirty dances at his club, and state authorities revoked the Golden Pine restaurant's license to sell alcohol. And although the Golden Pine eventually closed, the police department didn't last much longer than the restaurant. It was disbanded in 2021 because its officers mishandled so much evidence that prosecutors had to drop 31 criminal cases. In fact, the town spent so much time and money stopping its citizens from doing the tango that it forgot how to be an actual town. In 2022, the Virginia legislature revoked the town's charter after repeated failures to do basic things like pass a budget or maintain a wastewater plant. But if you thought that this stopped lawmakers in Western Virginia from regulating dancing, Well, think again. Wise County stepped up to make sure that the citizens of Pound and other citizens in the county did not fall prey to the vicissitudes of the cha-cha or the waltz. Today, Wise County regulates public dance halls, and the cops have the right to enter at any time to make sure that patrons are, quote, conducting themselves in a peaceable and orderly fashion. Wise County's anti-dancing ordinance repeats the same, quote, proper person language that the federal court found to be problematic. But on the upside, we'll probably get a sequel to Footloose sometime soon. Now, dancing kinda makes sense when you think about it, but did you know that pinball is considered the devil's balls? Well, when the Supreme Court struck down a federal ban on sports betting in 2018, states were eager to legalize gambling. 36 states and the District of Columbia now allow you to lose your shirt betting on the ponies, or, the Commanders, as the case may be. But America was not always so bullish on gambling. In the 1920s, moral scolds targeted coin-operated gambling machines like pinball. Now, no one loved to demonize pinball more than New York Mayor Fiorello LaGuardia. The man whose name is now emblazoned on one of America's worst airports wasn't shy about preaching pinball's links to juvenile delinquency. And World War II gave him a new talking point. Pinball was anti-American. After the Japanese bombed Pearl Harbor, Mayor LaGuardia said it was infinitely preferable that the metal in these evil contraptions be manufactured into arms and bullets which can be used to destroy our foreign enemies. And he banned pinball, and New York City police conducted raids on the city's candy shops and amusement parks. Now, mayors in Washington, D.C., New Orleans, Milwaukee, and Chicago followed LaGuardia's lead, and campaign photographs of the era show lawmakers and lawmen posing with the hammers they used to smash up pinball machines. Here's a newsreel showing the police proudly removing these dangerous objects after they were outlawed.
New York City completes a roundup of thousands of pinball machines, each valued at about $100. No more of this in Manhattan.
And the politics of pinball lasted well into the 1960s. Republicans thought they had JFK's number when they found a photo of him standing next to a man who was a silent partner in an Indiana pinball joint. Later, Kennedy's brother Bobby waged war on interstate pinball gambling. And to bring it full circle, attorney Jim Garrison, who tried to solve JFK's assassination, was indicted in 1971 for accepting bribes from a mafia kingpin who wanted him to protect pinball gambling. And you thought you lived in the dumbest timeline. But of course, the demonization of pinball made the game cool, and that's why so many movies and TV shows set in the 50s and 60s show their leather jacket wearing rebels playing pinball. But California finally put an end to this pinball madness when the state Supreme Court found that pinball was a game of skill in 1974. When the Los Angeles banned pinball in 1938, pinball players didn't have many ways to impact their score, other than by jostling the machine to manipulate the ball. But in 1947, flippers were invented, giving players more control over what happened to the ball after it was launched. And a group of business owners sued LA, alleging that the addition of flippers changed pinball into a game of skill that couldn't be regulated by the city. The trial court agreed, and the California Supreme Court affirmed, holding that the city's law was preempted by state regulation of games of skill. The court also suggested that treating games of chance differently than games of skill could violate the Equal Protection Clause. But the anti-pinball crusaders have not completely disappeared, though. In South Carolina, you can walk down any street openly carrying a handgun, but it's still illegal for minors to play pinball. The legislature is now, in 2023, gearing up for a big debate on whether to repeal the pinball ban. Gosh, really tackling the most important and potentially dangerous issues there in that election cycle. Now, if you're ever arrested for playing pinball, you'll probably need a good lawyer because the local sheriff probably has it out for you. But if you want a great lawyer, my firm, the Eagle Team, can help. If you've suffered an injury or death in the family, gotten in a car crash, or dealing with workers' comp or social security issues, we can represent you or help find you the right attorney who can. It's so important to talk to a lawyer right away so you can get the best representation and find out what your options are. So just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. The link is down below. Now, one of Johnny Carson's most popular bits was the Great Karnak.
Sis boom ba. Sis boom ba. Describe the sound made when a sheep explodes.
But fortune telling is not always a laughing matter. The Supreme Court has said that, quote, the First Amendment does not shield fraud. And in the old days, fortune telling was regarded as an inherently fraudulent occupation that was so deceptive that it could not qualify as free speech. The fortune tellers probably should have seen that one coming. And there are dozens of court cases confirming this view. For example, in 1928, the city of Cleveland charged Gertrude Davis with having violated Section 13145 of the General Code, prohibiting and penalizing fortune telling. The state law barred fortune telling without a license, but neither the city or the state actually provided a way for anyone to get that license. And the Ohio Supreme Court did not care about this particular catch-22, surmising that the words about licensing were just surplusage that could be read out of the statute. Davis argued that fortune telling was a legitimate business that wasn't wasn't penalized at common law, but as the court explained, the opposite was true. In the UK, palmistry, astrology, and fortune-telling were crimes, and the same was true in the Canadian and American colonies. People who practiced occult trades were not allowed to run legitimate businesses, despite the fact that kings and queens, and Nancy Reagan, consulted astrologists and fortune tellers for advice. Honestly, they probably should have seen that one coming too.
Are there any psychics in this town?
But the Ohio court rejected Davis's free speech claim on the grounds that the state had the power to regulate speech for the protection of the public health, safety, welfare, and morals. These are known as the state's police powers. And although Davis argued that the law infringed on her freedom of religion, the court disagreed, comparing fortune-telling to polygamy. However, for decades, fortune tellers have argued that they really are engaged in legitimate business activity protected by the Due Process Clause. And they say that the tales that they tell are protected by the First Amendment. And modern courts have started to legitimize fortune telling as a profession. For example, in 2010, a Maryland court struck down Montgomery County's ban on fortune telling. There, Nick Nefedro wanted to open a fortune telling business in Bethesda, but his father and grandfather always warned him that Montgomery County was hostile to Romani people. So Nefedro sued the county. The Maryland Court of Appeals originally suggested that the counties set up a licensing system, quote, whereby a psychic would have to accurately predict, say, 6 out of 10 events in order to obtain a proper permit. But eventually Maryland's top court ruled that the ordinance violated Nefedro's constitutional right to freedom of speech. Quote, we see nothing in the record to suggest that fortune telling always involves fraudulent statements. Indeed, fortune tellers, like magicians or horoscope writers, are able to provide entertainment to their customers or some other benefit that does not deceive those who receive their speech.
The cards can reveal things that you will never see by yourself.
And the Maryland court rejected the county's assertion that the ordinance regulated conduct, not speech. As for the county's argument that the law protected people from fraud, the court said, quote, while we recognize that some fortune tellers may make fraudulent statements, just as some lawyers or journalists may, we see nothing on the record to suggest that fortune telling always involves fraudulent statements. I'm not exactly sure how I feel about the court analogizing lawyering to fortune telling, but I guess when lawyers like Sidney L. Criquino Powell have become household names, and the court might have a point. But now that fortune telling is legal, finally America's rich, lonely people will have someone to talk to. States can still use anti-fraud laws when a fortune teller crosses the line. When does a fortune teller cross the line? When they commit larceny and fraud in the course of a psychic reading. Believe it or not all fortune telling is automatically considered abject fraud. For example, in 2018, the NYPD arrested Psychic Zoe on suspicion of defrauding clients out of over $800,000. She allegedly lured one victim in with a $5 reading and then convinced her that, quote, she'd never find love again unless she bought the psychic a 9.2 carat diamond ring. The same victim gave Zoe over $700,000 for spells and protections against demons. But look, you can't argue with results. She hasn't been attacked by a single demon since she's gotten those protections. Now, Psychic Zoe pleaded guilty to a scheme to defraud and was sentenced to probation and restitution. I guess she didn't see that one coming. Yeah, it used to be illegal to sell or buy alcohol on Election Day. Now, you might think that these laws were passed during Prohibition, but they're actually rooted in a very different time period. From America's earliest days, alcohol was synonymous with voting. I can't vote without it. But the first democratic body in the American colonies was the Virginia House of the Burgesses. And many of America's future leaders served in the House of Burgesses, including George Washington, Thomas Jefferson, Patrick Henry, and George Mason. And at the time, only white male landowners were allowed to vote, and they would line up at Williamsburg and state their preferences via voce. But it was customary for candidates to ply their voters with liquor during these events. And in fact, young George Washington tried to win a seat in the House when he was 24, but he was rebuffed after he decided against treating voters to booze. 3 years later, Washington ran again, but this time he showed up with 144 gallons of alcoholic drinks.
Let's do this.
Now, unsurprisingly, the landowners came through for Washington in a landslide. Washington gave away half a gallon of liquor or wine for every vote that he won. That's 391 votes to be precise. And Washington never forgot the power of booze. And according to popular myth, at the Battle of Trenton, he caught the Hessians off guard because they were so wasted.
Well, wait, we need to fight, but we're kind of drunk and we're kind of up.
And Washington eventually spent 7% of his White House budget on spirits. And this wasn't particularly uncommon. In the 18th and 19th centuries, politicians realized that since many saloons were also polling places, they could win votes by throwing raging keggers when the landowning men arrived in town. And getting voters sauced became a key strategy for getting out the vote on Election Day. It was known as, quote, swilling the planters with bumbo, which was a type of rum. And you have to admit, half a gallon of rum sounds better than 50 emails pleading with you to vote. And in the early 19th century, alcohol production went way up and consumption followed suit. This also meant that regular Joes and Janes could get their drink on, and that made America's elites sort of nervous. And by the mid-19th century, more people could drink and more people could vote, often at the same time. And drinking on election day occasionally led to violence, like the famous incident in 1882 when 3 McCoys stabbed Ellison Hatfield 26 times and then shot him to death. I guess they were really bad at stabbing. But William Devil Anse Hatfield organized a posse and caught up to the McCoys on their way to the Pikefield jail, where he kidnapped them, tied them to some pawpaw bushes, and shot them dead. And this all fed into the temperance movement, which eventually led to Prohibition. But when Prohibition was repealed, states continued to regulate the most serious problems created by alcohol. And this is how we got age requirements, Sunday bar closings, and tighter regulations on when and where alcohol was sold. The biggest perceived problem with alcohol on election day was that it led to public drunkenness and bribery of voters. And it took decades for the state to finally repeal the election day drinking laws, with South Carolina once again coming in last. The state didn't repeal its ban until 2014. However, candidates still can't promise individual voters liquor in exchange for votes, because that's just common sense. For example, in 2013, Arkansas State Democrat Hudson Hallam pleaded guilty to election fraud after he and several other men identified absentee voters, contacted voters directly with offers, and then collected the ballots. Hallam admitted that he bought the votes with things like chicken dinners and alcohol. And according to the DOJ, Hallam told his associate, quote, "We need to use that black limo and buy a couple of cases of some cheap vodka and whiskey to get people to vote." 2 days later, Hallam's cronies, quote, "spoke with an individual in Memphis, Tennessee about getting a discounted price for the purchase of 100 half pints of vodka for the campaign." Now, Hallam won his special election with 394 votes, strikingly similar to the 391 votes that Washington got back in 1758. But whereas George became America's first president, Hallam got 3 years of probation and 9 months of home confinement. Fortunately, this long-standing American tradition is still respected and embraced in our nation's fraternities. Of course, if you're gonna get trashed to vote this year, you should really sober up with a delicious home-cooked meal, which you can do with today's sponsor, HelloFresh. So let's say you decided to actually sit down and eat dinner around the table this year, but what about those nights when your schedule is absolutely packed? Well, you can turn to HelloFresh's lineup of quick and easy meals, including their 15-minute recipes, designed to help minimize mealtime stress. It's even quicker than delivery. You never have to worry about what's for dinner again, because HelloFresh is offering their biggest menu yet with over 45 recipes to choose from every week. Each HelloFresh box is packed with farm-fresh ingredients, and everything arrives pre-proportioned right to your doorstep for less hassle and less wasted food. It's a great way to eat delicious, fresh food while still being healthy. Now, I'm a do-it-yourself person, and I have to say I was initially pretty skeptical about HelloFresh. I'm a pretty good cook, so I didn't think that I needed the help. But I actually loved it. Even for an experienced cook, HelloFresh delivers new ingredients and recipes that I'd never try on my own. And of course, everything was delivered straight to my door, so I didn't have to do any shopping. The produce actually gets to you faster than a grocery store, so it arrives at peak freshness and flavor. And it's also super easy to save time. HelloFresh cuts out the meal planning and prep, so the recipes only take 20 to 30 minutes to cook, or even less. Literally less time to cook than it would normally take to do the shopping. And HelloFresh is at least 25% cheaper than takeout. And this is new because they say that breakfast is the most important meal of the day, and HelloFresh agrees. In fact, they're giving all subscribers free breakfast for life. That means that you'll enjoy a totally free breakfast item with every single HelloFresh delivery. So click on the link that's on screen right now or down in the description, or go to HelloFresh.com and use the code LegalEagleFree for a free breakfast item for life. That's one breakfast item free per box while the subscription is active. Again, just click on the link below and use the code LegalEagleFree at checkout for a free breakfast item for life. After that, click on this link over here for more Legal Eagle, or I'll see you in court.